This past weekend's D.C. rally aimed at protesting the arrest of the January 6th Capitol rioters had a lot of people concerned in the days leading up to it. But the event itself was small and uneventful, with fewer than maybe 100 demonstrators, far outnumbered by police, journalists, and counter-protesters. Event organizers blamed all the security for the low turnout, security that served as a reminder of just what happened at that January 6th riot, which many, including my next guest, argued Donald Trump incited. As a group of 3 top law professors recently wrote in the Washington Post, now that Trump is out of office, the DOJ's view that sitting presidents cannot be indicted no longer shields him. Attempted coups cannot be ignored. Among them, as I say, was Harvard Law Professor Emeritus Laurence Tribe, who joins me to talk about that, as well as why he believes the case he led here in Massachusetts decades ago could put an end to that Texas abortion law. Laurence Tribe, it's good to see you. Thanks so much for being here.
Good to see you, Jim.
What crimes do you think Donald Trump has committed? Actually, let me rephrase that. We only have a 30-minute show. What are the most egregious crimes you believe Donald Trump committed?
Well, I think the evidence is quite strong that he fomented an insurrection, violated the federal statute against conspiring to commit sedition, and violated various federal election laws by attempting to strong-arm Raffensperger and others to make up the big lie that he has used to claim that he really is still the president of the United States.
Raffensperger being the Republican Secretary of State in Georgia. You
Right.
taught Merrick Garland, so you have, I assume, some insight. Why is he not prosecuted, the former president?
Well, we don't know that he's not. Grand juries are secret. Mm-hmm. We don't know exactly what he's investigating. I'm hoping that he is building a case against all those who incited an insurrection and attempted to pull off a coup. But in his position, there are clearly a number of concerns you would have. You would certainly not want to indict a former president only to find that a jury ended up acquitting him because it had some reasonable doubt about one or another element of the crime. I think it was important to impeach the former president twice, even though it looked quite clear that he wouldn't be convicted by the Senate. But the Senate is so overtly a political body that an acquittal there really didn't clear the president's name. An acquittal by a jury of his peers would be a different matter. And so I don't envy Merrick Garland the difficult choice he has to make, but he's a methodical guy. He's undoubtedly looking at the facts and making sure that the U.S. attorneys involved, especially the U.S. Attorney for D.C., looks closely at the evidence.
You know, Joe Biden, as candidate and early on as president, went out of his way to say that unlike his predecessor, he would not treat the Attorney General as his personal lawyer. He didn't want it to be politically motivated. But in light of the fact that an indictment, no matter how buttressed by the facts it was, should there be one or more, would be seen as a political act, why not have Garland appoint, I don't know what the term is now, special prosecutor, independent counsel? Why not a credible outsider to reduce that political risk?
I think that might be a good move for Garland to make at some point, but he'd have to have a predicate for doing it. And whereas the existing regulations make a special counsel an appropriate step when the Attorney General is conflicted, it's not clear that there is a basis in the statutes or in the regulations for a special counsel here. Merrick Garland has no conflict of interest. And even though it might look better for a wholly independent person, not accountable to Joe Biden, to move on this matter, it would look terrible and be terrible to appoint someone without any authority to do so. And I think that might well be a real obstacle.
What's the long-term impact, consequence of a failure to indict Donald Trump for any of the offenses you enumerated?
I think it would be very sad. It would mean that the rule of law just didn't apply to the president when he commits serious crimes, the most serious crimes short of treason that a president can commit. And it would mean that this president, that is this former president, though he keeps calling himself president, that this former president could sail back into office, perhaps suppress votes in order to get there, or arrange to have Republican state legislatures elect him, even if he is rejected by the people, and then stay in office. It really would be an existential danger to the survival of representative government if he can get away with what he did, or what it looks like he did. So I'm keeping my fingers crossed that we will not have heard the end of this matter yet.
Coming back home to Cambridge, I used to, when I would think of Grendel's Den, I usually thought of the best salad bar I ever encountered when I first moved to Cambridge. But there's something a little more significant that it is famous for. You wrote in a piece that you believe the Grendel's Den case that made it to the Supreme Court, in which you were involved, in which a local ordinance allowed a church to veto a liquor license for Grendel's Den, and ultimately the Supreme Court said the government can't delegate governmental authority to a private entity with no accountability. You believe that fits perfectly into the issue of bounty hunters, private bounty hunters in the anti-abortion case. I got that right?
You got it right.
Okay, so even if it turns out you are right, Larry Tribe, doesn't that just postpone the inevitable in a court that, at least from my estimation, is hell-bent on either gutting or repealing Roe v. Wade?
Well, I do think the court is hell-bent on gutting or repealing Roe v. Wade, but I hope it's not hell-bent on gutting or repealing the rule of law. And what's wrong with the Texas law is not simply, although this is more than bad enough, not simply that it deprives women of control over their reproductive lives and their bodies, but that it does so without any public accountability, while evading judicial review through bounty hunters reminiscent of those that went after runaway slaves. That's profoundly wrong. It's wrong whether you believe in Roe v. Wade or not. And I'm hoping that the suit that was brought by Merrick Garland on behalf of the Justice Department for the United States recently, and that is going to be heard in the courtroom of a judge in the Northern District of Texas on October 1st, that suit will put an end to this kind of shredding of the rule of law. If the district court does enter a preliminary injunction of the kind that the Justice Department requests, there's a good chance that the Fifth Circuit, which is a bunch of very right-wing judges, not all of them, but most of them, will reverse. And then it'll come to the U.S. Supreme Court, and they will then have to face the music in a way that they didn't the first time around, when they could duck on various narrow procedural grounds. When the United States is the plaintiff, there is no sovereign immunity on the part of the state or its judges. And the Supreme Court will have a much harder time gathering a majority to let it go the second time around.
I hope you're right. But if you and I both agree, and I don't think we're alone, about what the ultimate goal of the Supreme Court is, it still has the Mississippi case that I think is going to be argued on December 1st. And they have one justice appointed by Trump in her late 40s, two in their young 50s. It seems to me that this is likely just the beginning of a whole series of comparable kinds of things. Yet when people talk about an antidote, for lack of a better expression, for example, enlarging the court, you wrote a piece in USA Today, I think it was last year, in which you said it's an understandable impulse, but it would lead to unending escalation. I assume meaning when the Republicans take over, they'd expand it more, et cetera. What is the alternative if it turns out that this very young court, at least the core of the very young, a conservative part of the court is so young, other than expansion, what's the remedy, Larry Tribe?
Well, I'm afraid that that's one issue that I'm really not able to talk about right now, because the president appointed me as one member of his commission.
Oh, right. right.
the Supreme Court of the United States. We're going to be submitting a report to the president in the middle of November. After that point, the gag that I feel I'm under at the moment will be lifted. I can talk about various possibilities, but right now that's something I'm afraid I can't really discuss.
Well, let me ask you a corollary thing before we part. There are many who believe that one step in the right direction would be for a very respected judge on the other side of the aisle, even though he doesn't acknowledge there are two sides of the aisle. Stephen Breyer stepped down, so we don't have a situation a la Ruth Bader Ginsburg, where a Joe Biden may not have, not only not be president, but may not have a majority, a 50 to 50 plus the vice president majority in the Senate. Should Breyer step down?
Well, that's another thing that I don't feel comfortable talking about. Most people who have the kind of views that I do have urged him publicly to step down. I think that doesn't make a lot of sense because he's desperate, whatever else he does, not to simply respond to political pressure from either friends or adversaries. If I were in his position, I don't think I would remain on the court. I think it takes a terrible risk that the things he believes in will simply be blasted out of the water. But he also does not want to play into the idea that judges are unduly political. And so he's under conflicting vectors of push and pull. And again, it's not a position that I envy.
I look forward to talking to you after that commission issues its report. Larry Tribe, thanks so much for your time.
Thanks, Jim.